Hello everyone. Welcome to Canadian Law Tutor. This is Virk, lawyer from Canada and your mentor in the NCA process. I've been providing free videos to everyone writing the NCA exams to clarify certain concepts. My videos are motivated by the questions I receive. If you have any specific question you would like me to answer that, I would be happy to have it in my next video. Many students are writing Administrative Law NCA exam and they have been approaching me to answer one question about privative clause. So students are confused about how to use it, how to identify it, and what is the relevance of this clause in our judicial review analysis. Privative clause is also known as ouster clause. If you have studied in UK, you must have heard the word ouster clause. So what is ouster clause or privative clause? They're pretty much the same clauses. It is legislative attempt to ouster the jurisdiction of the courts. So what is privative clause and how can we identify it in the exam? Privative clause means a clause which limits or completely prohibit the right of appeal or right of judicial review. So when you are analyzing a legislation in your exam scenario, you would look for a clause which simply says there is the decision of this particular tribunal is full and final. In some other situation, you would find that tribunal's decision is only reviewable on grounds of law. So the example number 1 is a full privative clause where we are not allowed to knock the door of the courts to appeal the decision of the tribunal. On the other hand, in the partial privative clause, the jurisdiction of the courts is limited. You can go to the court but not for everything. So you may be only appealing the decision for the limited grounds, for example law or mixed law and fact. If you have a pure factual grievances, that cannot be appealed in that particular scenario. However, after Vavilov, the presumption of reasonableness apply. So, privative clause is less important. We always start our question from the reasonableness standard as per the presumption laid down by Vavilov case unless it is rebutted by a correctness standard. So, what would you do with this kind of clause if you find an enabling legislation in your exam? As administrative law lawyers, we are still required to identify it and label it, whether it is partial clause or it's a full clause. I would sum up my today's video with my best wishes to all of you, and I hope you find it useful. So when you see a clause in the exam which talks about, whenever you see in enabling legislation a sample law, hypothetical piece of legislation, and you find there is no right of appeal available, or a term is used that the tribunal's decision is absolutely final and no review is available from this point onwards, you know you nailed it, that this is a privative clause. I hope you would find it useful in your exam and you will remember my words that privative clause is still relevant even after Vavilov case. As an administrative law students, we are required to identify it, explain it, and analyze it. If you like my video, please let me know, and if you still have a question about this subject or any other NCA subject, reach out to me on CanadianLawTutor.com. Thank you very much. I wish you all the best for your exam.